significance apart from its effect on the will. And this act or event can happen before or after the will is signed, even after the testator's death.
Give me an example.
Sure. A classic one is I give $1,000 to each person who is employed by my company at the time of my death. Who is employed is a fact with independent significance running a business separate from the will itself. Or I give the contents of my safe deposit box to my sister. What's in the box might change, but opening the box has significance apart from the will. It allows flexibility for changing circumstances.
That's clever. And our source flagged a key timing difference between these two for essays.
Absolutely critical distinction. Incorporation by reference and republication by codicil only works for things that exist in the past. The document must exist when the will or codicil is signed. Acts of independent significance is the only one that works for future acts or events that happen after the will is executed. Nailing that time difference is key for analysis. Ambiguities and mistakes.
Golden nugget right there.
Yeah.
Okay, last bit on construction. Ambiguities and mistakes in the will's language. Do courts try to fix unclear wording or obvious errors?
Courts are generally hesitant to rewrite a will based on a perceived mistake because they want to uphold the testator's words. The plain meaning rule is strong. However, they will allow extrinsic evidence outside the will in two main situations. First, to show a mistake in the execution itself, like signing the wrong document.
Okay, mistake in the signing process.
Second, to resolve ambiguities in the will's language. If a term is unclear or could mean two different things, a latent ambiguity that only appears when you try to apply it, or a patent ambiguity clear on its face, courts will hear evidence to figure out what the testator likely meant. Also, if language seems to condition the will on an event, this will is only valid if I die on my trip, courts often interpret that as just explaining the motive, not a strict condition, trying to validate the will if possible.
We've covered the will itself inside and out. Now let's look at legal protections and rights that might override or supplement the will. Power to transfer, rights of spouses and children. Beyond what a will or intestacy might give, what general support rights does a surviving spouse usually have?
Yeah, the law provides a safety net. Surviving spouses often have rights to things like Social Security benefits, maybe pension benefits, a homestead exemption, the right to occupy the family home for a period, rights to certain personal property, and often a family allowance, temporary payments from the estate during administration to cover living expenses. These are statutory protections. Elective share, forced share.
And then the big one, the elective share or forced share. This is the major tool to stop a spouse from being totally disinherited, right?
Exactly. A very significant spousal protection, especially where you can disinherit a spouse otherwise. In common law property states, it's called the elective share. The surviving spouse has a choice. Take what the will gives them or elect against the will and take a statutory percentage, often 1/3 or 1/2, of the decedent's augmented estate.
Augmented estate, what's that include?
That's key. The augmented estate usually includes not just the probate estate, but also certain non-probate transfers the decedent made during life that might have been intended to defeat the spouse's share, like certain gifts or irrevocable trusts. It pulls those back in for the calculation. This right can be waived, though, in a valid prenuptial or postnuptial agreement with full disclosure.
Okay, so common law states have the elective share. What about community property states?
In community property states, the spouse already owns half of the community property acquired during the marriage, so they have a forced share right to that 1/2. If the decedent's will tries to give away the spouse's half or give them less overall, the spouse can elect to take their guaranteed community property share instead of what the will offers.
So either way, there's a mechanism to ensure the spouse gets a minimum share. What about an omitted spouse? Someone married after the will was written.
Right. An omitted spouse is someone who marries the testator after the will is executed and isn't provided for in that will. The law generally presumes this omission was accidental. Yeah, a presumed mistake. So the omitted spouse is usually entitled to receive the share of the estate they would have gotten if the testator had died intestate, without a will. It's meant to prevent accidentally disinheriting a new spouse with an old will.
But that presumption can be rebutted. How?
Yes, it's rebuttable. The estate can show the omission wasn't a mistake if the will itself makes it clear the omission was intentional, like this will applies even if I marry later, or if the testator provided for the spouse outside the will, like a big life insurance policy naming them, or under the UPC if the spouse waived their rights in a valid prenuptial agreement. It's about showing the omission was deliberate or compensated for elsewhere.
Gifts to children.
Okay. Proving intent or alternative provision. What about gifts to children? Let's talk advancements. What are those? Advancements relate to lifetime gifts possibly counting against a child's inheritance. Again, common law and modern law differ. Under old common law, a substantial lifetime gift to a child was presumed to be an advancement, an early payment of their intestate share. The child had to prove it wasn't meant that way.
Presumed to be in advance.
Right. But the modern trend in the UPC reversed this. A lifetime gift is not treated as an advancement unless the decedent declared it as such in a writing made at the time of the gift, or the heir acknowledged it in writing as an advancement. Needs a clear paper trail now to count against their inheritance share. Prevents fights over past gifts.
Much clearer rule now. What about managing property for kids who inherit? How's that usually handled?
If a minor inherits property, they can't legally manage it themselves. So it's usually handled through a formal court-supervised guardianship of the property or a custodianship under the Uniform Transfers to Minors Act, UTMA, which is often simpler, or a trusteeship if the property was left in trust for the minor. The UTMA is very common. A custodian manages the property for the minor's benefit until they reach a certain age, usually 18 or 21.
And omitted children. Similar idea to omitted spouses. Born after the will.
Very similar concept. If a child is born or adopted after the testator executes their will and the will doesn't provide for them, there's a rebuttable presumption the omission was accidental. That child is generally entitled to a share of the estate.
And how do you rebut that presumption for a child?
Similar ways. Show the omission was clearly intentional in the will, or show the testator had other kids when the will was made and left basically everything to the omitted child's other parent, implying that parent would provide, or show the testator provided for the child outside the will.
Okay, intent or other provision again. If the child does take a share, how much do they get?
Depends. If the testator had no other children living when the will was made, the omitted child usually gets their full intestate share. But if the testator did have other children provided for in the will, the omitted child's share is typically limited to taking proportionally from the gifts already made to the other children. They share in what the siblings got, essentially. Bars to succession.
Okay, that makes sense. Finally, what things can completely bar someone from inheriting? Situations where they just legally cannot take.
Two main ones to know. First, homicide, the slayer rule. A person who feloniously and intentionally kills the decedent cannot benefit from that death by inheriting from the victim, either by will or intestacy. They're treated as if they predeceased the decedent. Public policy.
Can't profit from murder. Makes sense.
Right. Second, disclaimer. A beneficiary can formally refuse to accept a gift under a will or an intestate share. They have to do it properly, usually in writing within a certain time. If they disclaim, they are also treated as having predeceased the decedent, and the property passes to the next person in line, often their issue via anti-lapse.
Now, we've seen how wills work and how gifts flow. But what if someone thinks the will itself is fundamentally flawed? That it doesn't reflect what the testator really wanted? This brings us to will contests. Challenging a will's validity. What's the basic idea here? Who gets to challenge a will and when?
A will contest is a formal lawsuit objecting to the validity of a will, arguing it shouldn't be admitted to probate because it doesn't represent the testator's true intent, usually due to some defect in its creation or execution.
And there are time limits. And not just anyone can sue.
Definitely time limits, usually a fairly short window after the will is offered for probate, often around 6 months. And no, not just anyone. You need standing. Only interested parties can contest people who stand to benefit financially if this will is thrown out. Maybe they'd inherit more under a prior will or through intestacy. They need a direct financial stake in the outcome.
Gotta have skin in the game.
Yeah.
What about jurisdiction? Where do these contests happen?
Traditionally, common law said the law of the state where the testator was domiciled at death governs validity. The UPC is more flexible, allowing validity to be determined under the law of the place the will was executed, or the place of domicile. More options. Grounds for contest.
Okay, limited time, need a financial interest. What are the main reasons someone might challenge a will? The core grounds for a contest.
The big ones you'll see tested are lack of testamentary capacity. The testator was suffering from an insane delusion that affected the will was the product of undue influence, or the will resulted from fraud. These are the main lines of attack.
Let's revisit testamentary capacity. We defined it earlier. What's the focus when arguing someone lacked it?
The focus is proving that at the moment the will was signed, the testator lacked the ability to understand those 4 key things: the nature of the act, making a will, the nature and extent of their property, the natural objects of their bounty, their family, and the disposition plan itself. If you can show they couldn't grasp one of those elements right then, capacity was lacking, will is invalid. It's about their cognitive state at that specific time.
And insane delusion. Sounds pretty extreme. What makes a belief legally insane?
It is pretty specific. An insane delusion is a belief with no basis in reality, one that a rational person couldn't possibly hold, but the testator clings to it despite all evidence.
Just a completely unfounded belief.
Right. But crucially for essays, just having an insane delusion isn't enough. The challenger must show that the delusion caused the specific problematic provision in the will. It has to be the but-for cause. The weird gift wouldn't exist but for this specific delusion. If the delusion didn't affect the will's terms, it doesn't invalidate it. Causation is key.
Causation again. Got it.
Right.
What about undue influence? Sounds like someone pressuring the testator.
Exactly. Undue influence is mental or physical coercion by someone that overcomes the testator's free will, causing them to make a will or gift they wouldn't normally have made. It results in an unnatural disposition. If undue influence is proven, the influencer is often treated as if they predeceased the testator, at least regarding the tainted gift, so they don't profit from the coercion.
And the majority rule has 4 elements to prove undue influence. These sound critical for essays.
Absolutely critical. Memorize these. You need to show. 1. Susceptibility. The testator was vulnerable, old age, illness, dependency. 2. Motive predisposition. The influencer had a reason or desire to influence. 3. Opportunity. The influencer had the chance to exert pressure, access, isolation. And 4. Causation. The influence did cause an unnatural result. The will wouldn't be this way but for the influence. All 4 needed.
And there's also a presumption of undue influence that can flip the burden of proof.
Yes, very important. A presumption arises if the main beneficiary had a confidential relationship with the testator, like attorney-client, doctor-patient, or just deep trust where one person is dependent, not usually spouse-spouse, and that beneficiary actively participated in procuring the will. If those are met, the burden shifts to the beneficiary to prove there wasn't undue influence. But again, even with the presumption, causation linking the influence to the gift must still be shown.
So confidential relationship plus active procurement shifts the burden, but still need causation. How does fraud differ from undue influence?
Fraud is about deception, trickery. Undue influence is about coercion. Fraud is a beneficiary making a deliberate misrepresentation to the testator, intending to deceive them and influence the will, which results in a provision that wouldn't exist but for the lie. Again, but for causation is essential. The fraud must have directly caused the gift. Okay, coercion versus trickery. Last point here. Forfeiture provisions or no contest clauses. Clauses saying if you challenge this will, you get nothing. Are those enforceable?
Not always. This is important. These clauses, also called interrogatum clauses, aim to scare beneficiaries away from contesting. But, under the UPC and in most states, they are unenforceable if the beneficiary who contested had probable cause to bring the challenge. So if you had a good faith, reasonable basis for suspecting undue influence or lack of capacity, the no contest clause won't stop you from getting your original gift, even if your contest fails. It protects legitimate challenges.
So probable cause is a shield.
Exactly.
Huh?
Also, clauses trying to broadly restrict marriage, you lose your inheritance if you ever marry, are usually void as against public policy.
We've covered a ton on wills themselves. Now let's shift to the aftermath. Probate and administration, the process after death. You mentioned earlier, and I want to hammer this home, the absolute first step is separating probate and non-probate property. Why is that the starting line?
It is absolutely the critical first step, the foundation of your entire distribution analysis in an essay. You must distinguish probate property stuff passing under the will or intestacy from non-probate property stuff passing outside the will via other instruments like trusts, joint ownership, beneficiary designations.
Why first?
Because non-probate property passes automatically according to its own rules, before the will or intestacy even gets looked at. The flowchart in our source shows this clearly. Identify joint accounts, life insurance, trusts, distribute those assets first based on their terms. Only what's left is the probate estate, which is then subject to the will or intestacy rules. If you don't pull out the non-probate stuff first, you'll be applying will intestacy rules to assets they don't control. Derails everything.
So, step 1 always. Identify and distribute non-probate assets. Then look at what's left. What about the basic probate procedure? Where does it happen? Any deadlines?
Jurisdiction usually lies in the county where the decedent was domiciled at death for personal property and local real estate. Ancillary probate might be needed for real estate in other states. Most places require notice to heirs, beneficiaries, and known creditors before someone is formally appointed to manage the estate. As for timing, common law had no strict deadline, but the UPC generally requires probate to be initiated within 3 years of death, a clear statute of limitations.
And creditors. Debts have to be paid before beneficiaries get anything, right? How does that work?
Absolutely. Paying debts is a primary function of probate. The personal representative has a duty to notify creditors, usually by publishing notice and sending direct mail to known ones. Creditors then have a limited time to file their claims against the estate.
And there's an order for paying them.
Yes, a strict statutory priority list. This is crucial because it determines what, if anything, is left for beneficiaries. The typical order is 1. Estate administration costs, attorney fees, court fees. 2. Funeral expenses and last medical bills. 3. Family allowance, support for dependents during probate. 4. Taxes. 5. Secured debts, like mortgages, up to the value of the collateral. 6. Judgments against the decedents. 7. All other general unsecured claims. You pay down the list until the money runs out.
So admin costs first, then funeral, medical, etc. Beneficiaries are last in line. Who is the personal representative managing all this?
The personal representative, PR, is the person or entity appointed to wind up the decedent's affairs. If named in the will, they're the executor. If appointed by the court, no will or executor can't serve, they're the administrator. They have a fiduciary duty, the highest duty of loyalty and care to the estate's beneficiaries and creditors.
Are they personally liable if things go wrong?
Depends. Common law could hold them personally liable for mismanagement. The UPC offers more protection. Typically, the PR is sued in their representative capacity for breach of duty, meaning the estate assets are usually on the line first, not their personal funds, unless they acted improperly.
And if the will doesn't name someone, or they decline, who gets appointed? Is there a pecking order?
Yes, statutes set out a priority list. Generally, 1 person named in the will, 2 surviving spouse who is also a devisee, 3 other devisees, 4 surviving spouse even if not a devisee, 5 other heirs, 6 creditors, but usually only after 45 days. It provides an orderly way to appoint someone.
And what are the PR's main jobs, the core duties?
Key tasks include giving formal notice to beneficiaries, heirs, and creditors, inventorying, collecting, valuing, and managing the estate's assets, paying all legitimate debts, taxes, and expenses according to that priority list, and finally, distributing the remaining assets to the rightful beneficiaries according to the will or intestacy law. It's a big job with a lot of responsibility. Hashtag tag 1X. Powers of appointment and powers of attorney. Brief.
We're nearing the end, but let's quickly touch on 2 related concepts. Powers of appointment and powers of attorney. First, powers of appointment, what are those?
A power of appointment is basically a right given by one person, the donor, often in their will or trust, to another person, the don, allowing the don to decide who gets certain property. It's like delegating the decision.
Delegating the choice of beneficiary.
Right. 2 main types. A general power lets the don appoint the property to anyone, including themselves, their estate, or their creditors, no restrictions. A special power limits who the don can appoint the property to, like only among my descendants, or not to the don themselves.
General is wide open, special is limited. How do you exercise one? Does just saying, I give away all my property in the duns will work?
A power created in a will, a testamentary power, must be exercised in a will. And crucially, a generic residuary clause in the Dundee's will, I give the rest of my estate to X, usually does not exercise a power of appointment unless it specifically refers to powers of appointment or the power itself. You generally need explicit intent shown in the Dun's will to exercise the power.
Need to be specific. Okay. What about powers of attorney? Lots of people have those. How do they relate to wills?
A power of attorney, POA, is a document where one person, the principal, authorizes another person, the agent or attorney in fact, to act on their behalf in financial or legal matters while the principal is alive.
Doing life. Okay.
Right. A general POA covers broad authority. A specific POA is limited to certain tasks or times. Most states presume POAs are durable, meaning they remain effective even if the principal becomes incapacitated. But all POAs automatically terminate when the principal dies. Wills take effect at death, POAs end at death. Also, the principal can revoke a POA anytime they have capacity, and the agent usually only has liability for intentional misconduct.
Critical difference. POA is for lifetime management, ends at death, will kicks in at death. Got it. Wow. We have covered an incredible amount of ground. Intestacy, will formalities, revocation, contracts, construction, rights of spouses and kids, contests, probate. It's a huge landscape. But now let's bring it all home for your bar exam essays. This is the payoff. Tackling wills issues, your essay roadmap.
This truly is the practical key. How do you take all this doctrine and apply it logically under time pressure? Our source material has an excellent flowchart that gives you the exact structure. Follow this roadmap and you'll hit the points methodically like a pro. It's your blueprint.
Okay, lay out the blueprint. Step one, what's the absolute first question you ask yourself when you get a wills essay?
First paragraph, first thought. Is there non-probate property? Look for assets passing outside the will joint tenancy, POD accounts, trusts, life insurance payable to a named beneficiary. Identify them, explain why they're non-probate, state who gets them according to their specific terms, and mentally or literally set them aside. They are resolved first.
Clear the decks of non-probate assets. Got it. What's step two?
Once non-probate is handled, ask, is there a valid will? This is where you analyze all the execution requirements. Writing, signature witnesses, intent, capacity. Was it a holographic will? Was there substantial compliance if formalities weren't perfect? And critically, this is also where you analyze any challenges to validity, lack of capacity, insane delusion, undue influence, fraud. Does the will, or part of it, survive these attacks? If yes, you then figure out how to distribute the probate property according to its terms.
Okay, analyze the will's validity, including any contests. What if there's no valid will? Or the will is valid but doesn't cover everything that's left?
That leads straight to step 3. Apply intestate succession rules to any remaining probate property. If there's no valid will, or if the valid will doesn't dispose of everything, maybe no residuary clause, then whatever probate property is left passes via intestacy. This is where you apply all those rules about who inherits, spouse, issue, ancestors, collaterals,
Right.
and how their shares are calculated, per stir base per capita, etc.
So it's a clear sequence. Non-probate, valid will. Intestacy for anything left. That structure really connects all the pieces logically.
Exactly. It ensures you address everything in the right order. Will contest issues. They fit under step 2. Is the will valid? Problems with interpreting gifts like redemption or lapse. Those fit under step 2 as well, after you've determined the will is valid and are figuring out how its terms apply to the property.
And things like abatement, the order of reducing gifts, that also comes after confirming the will is valid when you're executing its terms but find the estate is short.
Precisely. Redemption asks if the gift still exists. Lapse asks if the beneficiary is still eligible. Abatement asks who gets cut if there's not enough money. All are part of analyzing the consequences of a valid will. Following this roadmap, non-probate will validity contests, will construction distribution, intestacy for leftovers keeps your analysis organized and ensures you cover all the bases methodically. Hashtag outro.
What a deep dive. We've really unpacked the world of wills today, from what happens with no will at all, through making one, changing one, fighting over one, and finally the process after death. And most importantly, we've given you that roadmap for structuring your bar exam essays.
Absolutely. By breaking down the source material and connecting the dots, you should now have a much stronger toolkit. Remember, it's not just memorizing rules, but understanding how they fit together and applying them systematically. Hopefully you feel less overwhelmed and more strategically prepared now.
Definitely. So here's a final thought for you to mull over, especially as you think about the real-world impact of these laws. Considering all the complexity we've discussed, the different state rules, the formalities, the presumptions, if you could rewrite one single rule in your state's intestacy laws or will execution requirements, what change would you make to simplify things or make the process better for everyday people, and why? Something to chew on. We really hope this deep dive gives you more confidence tackling this fundamental area of law. Keep digging, keep asking questions, and remember, truly understanding the why behind the legal rules is the key to mastering them.